witness, or in the form of documents such as reports from agencies and the like. You may use any reliable source of information concerning any facts or matters upon which you intend to rely in reaching your determination of whether the applicant has proved its right to the relief requested, so long as that information is part of the record of the case. Expert witnesses. In addition to the factual evidence presented, the parties may call witnesses as experts in a particular field. Once qualified as an expert, that witness is able to answer hypothetical questions based upon his or her ability to draw inferences from the facts presented. In this case, the board has heard testimony of several witnesses, which the board has accepted as experts and about which I will comment below. The predominant issue discussed during the course of the hearings has been whether the proposed operation of the applicant's tenant's facility, a fragrance blending operation, would, through its air emissions, create public health and safety conditions harmful to the well-being of neighboring residents or more broadly within the borough generally. A very general summary of the positions of various parties follows for the purpose of advising you on your consideration of expert testimony. You are the finders of fact, and if anything I state here is at variance with your recollection controls. Additionally, there's a wealth of facts beyond what I summarize here, which have been discussed over the course of the 12 hearings you've held to date. The applicant produced fact and expert witnesses concerning the proposed operation of its facility. They described the equipment to be used consisting of air intake devices, a carbon filtration system, and strobic fans. They employed the use of a dispersion model, which was said to result in the emission of substances resulting in low concentrations at the nearest property line of single-digit parts per trillion. An expert offered by applicant, Dr. Andrea Dugan, testified that exposure at that level would be considered safe for the reasons she advanced. Many residents presented testimony expressing serious concern over the potential public health and safety consequences arising from the proposed operation of the blending process use proposed by the applicant. One individual, Dr. Colin O'Reilly, a medical doctor and member of the Board of Health, was offered as an expert experienced in the treatment of people exposed to substances which had caused harmful health consequences, and as knowledgeable on the origins and creation of conditions which lead to such exposures. The thrust of his testimony was 1, to reinforce the concerns of the Board of Health, and 2, to state his opinion that insufficient information had presented to assuage his and the Board of Health's concerns for the reasons he advanced. Also testifying as an expert this evening, Mr. Batacles, I hope I pronounced that correctly, enumerated numerous concerns over the potential adverse health effects which he listed as being presented by the proposed use, and criticized positions advanced by the applicant pertaining to a state-of-the-art facility, the handling of a worst-case scenario disaster, monitoring, and other issues. The board retained the services of 2 experts concerning public health and environmental safety and concerning toxicology. They described the facts upon which they relied for their analysis, their knowledge and experience in the field over time, and the methodologies utilized in coming to their conclusions. They concluded that the proposed use does not pose a public health and safety risk for the reasons they advanced, including that very low concentrations of substances emitted into the air from the facility would be orders of magnitude below potentially harmful levels. As in the case of all expert testimony offered on all of the various topics covered during the hearings, including but not limited to traffic, noise, zoning relief, project layout, as well as public health and safety impacts, the board members individually and collectively have the right to decide which testimony they regard as more persuasive, reliable, or credible, and accordingly will best inform the determinations to be made by them in connection with the application. conflicting evidence. Where the evidence before the board is conflicting, the board must decide what facts it will rely upon. For example, the board has the choice of accepting or rejecting testimony from all witnesses, fact witnesses, as well as expert witnesses. In particular, your decision should be based on your own assessment of the credibility of the witnesses and the weight to attribute to that testimony. If you deem that certain testimony is not credible, you have the right to reject it for that reason. In other words, in face of conflicting expert testimony, you are free to decide which expert testimony you will accept. Judicial notice. The board is also entitled to take judicial notice of such matters that are of common knowledge, such common knowledge that the matter is not subject to reasonable dispute. You're also free to take judicial notice of the zoning and planning laws of New Jersey and the borough's development ordinances, as well as determinations of governmental subdivisions or agencies of New Jersey. Relief granted. The board is not bound to grant or deny the specific variance or other relief requested. In appropriate circumstances, the board may determine that the applicant has only proven its right to some portion of the relief requested, or may grant additional relief arising from the hearing testimony. Imposition of conditions. It has long been recognized that in granting an application, a board may impose conditions to safeguard the public interest, so long as they are reasonable and advance some purpose of zoning. Where it appears to be proper to grant an application, and you deem the imposition of conditions as necessary to advance the public interest, you should impose those reasonable conditions which carry out a legitimate land use objective. Enforcement of conditions. The decision of whether to impose a particular condition on the grant of a variance relief or other relief should not be based on whether the condition is enforceable. This board is not an enforcement authority. If a condition contained in a board approval is violated, there are procedures available to the borough code enforcement officer, the governing body, and even adjoining property owner or interested party to seek redress for that violation. However, there may